All right, hi class. You all did pretty well last week. So this week, for week 2, main instruction in the video here is going to be how a criminal court case proceeds in Canada. Next week we'll do civil court cases. So last week we had the 3 broad categories of law: customary, which is outside of government or any sort of institution with an enforcing power, just customs across culture, forming laws that people tend to obey to fit in with a community. We had case law, which involves the authorities and is set by a precedent of many past decisions of court cases and government documents. Then we have statutory law, where a law written out by the government is very specific and the law is rooted right in what's written down. Okay, and Canada has elements of all 3. We'll look into that later. This week, within that framework, so case and statutory law both affect criminal cases and civil cases where there's no allegation of a crime, but there's disputes and people appeal to the courts for a resolution. Okay, so we're going into criminal cases, and from this overview of how a criminal case proceeds, we'll go into a discussion question where we basically say, do we think this is a fair system? Or do we see ways where it can be abused and we would change the process in some way? Okay? You'll see key points in this process where if you do some research on, you could look up corruption in Canadian judicial system, corruption in American judicial system, or suggestions for reform of Canadian justice, reform of American justice. You'll see that in this process, there's room for corruption and abuse. And if you can point out where the Crown, the government, the prosecution trying to get a conviction could abuse the process, and where the defense or judges that might have a tendency to be too lenient with the defense, where they could abuse the process, that will be our discussion. Can you identify something where corruption can happen, and how would you address that? How would you reform it to improve the system? Okay? If you think it works really well and you can't see anything, then say what you like about this, why you think it doesn't need to be changed, and then engage respectfully with others who might disagree and say that there's some problems with this approach. Okay? Remember, to get full participation marks, you need to reply to 5 other people and give at least 3 sentences saying something meaningful in response to what they said. That's where we get our class participation going. Okay, so here is how a criminal court case proceeds in Canada. The assignment due next Monday is going to explain itself in the assignment page. All right, so a criminal charge leading to a trial in court usually proceeds as follows. An arrest is made by police. The nature of the charges and options for legal representation are explained to the person being arrested. This is where Miranda rights, rooted in Magna Carta, that you hear in the movies come from, such as, if you cannot afford an attorney, one will be provided for you, as someone's being arrested. Both in criminal and civil law in Ontario, there are private legal aid charities and a government-subsidized legal aid service to provide lawyers for those who cannot afford one. All right, going from there. Sorry, just need to fix something on the computer. Legal aid charities, where we left off. All right, the individual arrested and given these Miranda rights is released before a trial or held in custody, depending on the severity of the crime and the judgment of the police as to whether the suspect is likely to flee the region or not and go to another jurisdiction. Jurisdiction means new place where new authorities enforce laws, and they might not help the other jurisdiction. Okay? Regardless of whether they're held or whether they're allowed to move freely in the region where they've been accused, the next step is called first court appearance or arraignment. This will be the first actual court appearance, and the individual will be charged. This person will also state whether they are going to be pleading guilty or not guilty. So in a way, charge is like the legal phrase for alleged crimes. Being charged does not mean that you're going to be convicted, which would actually mean that you were determined guilty and actually convicted for a crime and you have to do consequences. Okay, so after you got arrest, you have first court appearance, arraignment. After the first court appearance or arraignment, you have disclosure. All right, so disclosure is an important step where the Crown discloses to the defense everything that they have in terms of charges and evidence to support a conviction. Even if the evidence helps the defense, all evidence must be disclosed here. Nothing can be withheld. Crown is the term for the prosecution in Commonwealth countries like Canada, since the government is rooted in our heritage of being a monarchy. So anything that's in the government, in the civil service, outside of the elected legislature, is technically the Crown. They're representatives of the Crown. Crown has become a synonym for government in Canada, Britain, Australia, places with a Commonwealth heritage. Okay? The duty of disclosure is only on the Crown or prosecution, and a defense doesn't have to disclose anything to the Crown. The sole exception to this is if the defense will be making the argument of alibi. If they are, the court asks the defense to disclose this so the police can look into it. An alibi is a story that would make it impossible for the accused to have been the offender in a reported crime. Means of committing a crime, motive to do so, and opportunity to do so all need to be proven. And if an alibi removing all three from the realm of possibility has irrefutable evidence of being true, then the case is dropped immediately with no record of charges or conviction. A quick example can be if someone is typecast by police for committing a robbery at a gas station by appearance. They just happen to look like the person who did the robbery. But this person has receipts and a doctor's note confirming they were miles away at a medical appointment. Then at that point, it's all dropped. They have proof of the alibi. After disclosure, the two legal teams of Crown and Defense will meet for a pre-trial conference. Here, the two sides will discuss the case and will explore if any common ground can be reached. This often takes the form of a plea deal. A plea deal often involves the accused pleading guilty and accepting a conviction with consequences on a smaller crime, therefore with lighter consequences, that is easily provable. And they do this in order to prevent worse sentences on a bigger crime and a long, drawn-out, stressful, or embarrassing court trial. Whether the plea deal is accepted or the accused continues to plead not guilty on all charges, you then have a judicial review trial. This will always be with a judge. The judge here is going to talk to the two sides and try preemptively to work through tough issues that may arise during the trial. He may also highly encourage the sides to settle if he feels that it would be best for all parties, he or she, as the judge. This is very common in civil court cases, which we will cover next week. If no deals are made at this point, a trial begins. A trial usually goes in the following order: opening statements from the judge, summarizing key names of the Crown, defense, accused, and what the alleged crimes are. The Crown makes their case first, narrating all key facts to the judge and oftentimes jury. Sometimes court cases have a jury, sometimes they don't. The defense, after main arguments, will ask for summary judgment because the Crown didn't do their job if the evidence is weak and corruption may be at play, where powerful people are using allegations of crimes to attack someone they don't like. The judge will decide if they are going to continue or not. If they continue, the prosecution or Crown's opening arguments will then usually involve witnesses and experts as further evidence of a crime. Sometimes the arguments are a narrative and then they give Exhibit A, Exhibit B, different material objects that could prove the crime, but there's usually witnesses and some experts who could address and be giving further evidence of the crime being committed by the accused. Okay, after these people come up, they're examined by the Crown. That's examination of witnesses and experts. The defense then has a chance to cross-examine these witnesses and experts, trying to show inconsistencies, trying to poke holes in the case being made by the Crown and by the witnesses. Regardless, after cross-examination, that kind of dovetails into the defense's main arguments. Defense will give their main argument for why the accused is innocent. They will give their own witnesses and experts usually, and this leads to another round of the Crown prosecution cross-examines the defense's witnesses and experts, and both sides, Crown first, then defense, get to re-examine. Like, witnesses and experts can be examined or questioned 3 times if the re-examination happens, trying to set the record straight if one side thinks the other is giving misleading questions and information. Okay, at any point during main argument, examination, cross-examination, then defense, main argument, examination, cross-examination, any point in that process could see a lawyer from either side interject and give an argument very quickly with legal terms that we'll learn about later, saying some type of evidence is not admissible in court given the circumstances. The judge will either say objection accepted and the current line of questioning or type of evidence has to be removed, or objection sustained and they don't think it's illegitimate, they think it is legitimate, and questioning or arguing continues. Presentation of an argument continues. After main arguments, examination, cross-examination, you get closing arguments from both sides, where it's just both sides summarizing why the judge and sometimes jury should convict the person, or why they should, if it's the defense, why they should not convict the person. You finish with closing arguments. Okay? Then it's actually a future trial where sentencing happens. The judge, with input from a jury, if there is a jury, or on the judge's own judgment after hearing all the arguments and seeing all the evidence, at the future trial, the last trial, sentencing trial, you have first appearance arraignment, you have judicial review trial where most of the action happens, then you have sentencing trial. It will either be not guilty or guilty on one or all charges with here's what the conviction comes with, here's the sentence we're giving you. The sentence is the word for consequences the accused must fulfill to either do jail time, pay a fine, do different things, after which they can come back to polite society. All right, that's the basic approach. Obviously, for minor offenses and speeding tickets, it can very quickly just go to a plea deal. Lots of speeding tickets and minor offenses. It's the same day. First appearance also comes with offers for how you can get rid of it quickly if it's a minor offense. Okay, usually that's like a fine is paid, or a course is taken, or community service is given. But for major crimes, that's the order you have. You have arraignment, first appearance, where they hear what they're accused of. Usually they know a fair amount because they were arrested. After the arrest, you get to the first appearance, the arraignment. After the arraignment, there is a disclosure meeting of all evidence from the Crown and possibly a plea deal. After that disclosure meeting, you get into a first judicial review trial if no deal is met. After a judicial review trial where all arguments and evidence are given, you have a sentencing trial. Okay? Big thing to look at for your discussion question would be whether or not to hold a criminal, how that's currently up to the discretion of police, the nature of disclosure meeting, okay, and the plea deal negotiating meeting, okay. In between first court appearance, arraignment, and the trial, you have this meeting where prosecution offers evidence and plea deals can be offered. Then you have the trial with judge giving a summary, opening arguments, examination, cross-examination for the Crown, same for defense. Okay? If those are really the 3 points where some people think that there could be corruption going in either direction, of either having too many convictions or having too little in the realm of convictions. Okay, that's what you're going to discuss. Do you think this is a fair process? I'll have a reminder that you can read through of the process. Is it fair? If yes, say what you like about the process. If you think there's room for improvement, if you see openings for how it can become corrupt and unfair, explain what could become corrupt and unfair. And then that will drive your post and your replies to other people's threads, and we'll engage with each other. All right. Thanks, guys. Have a good one.